What is an affidavit?
An affidavit is a voluntary sworn statement made under oath used as verification for various purposes.
So it's like a statement then?
Yeah, it's pretty much a statement. It's a form of written sworn testimony as opposed to oral testimony.
So could somebody lie in their affidavit and get away with it?
Yes, you can, but it's not a good idea because when you're lying in an affidavit, you're under oath. You're swearing to the veracity and the truth of the statements that you made, and you're swearing under penalties of perjury. So, can you lie? The answer is yes, but you're subjecting yourself to the penalties of perjury. So, you're subjecting yourself to jail time, and it's unnecessary. You're not supposed to lie in an affidavit, so no.
Okay, so if someone does lie, say someone submits an affidavit and then they realize that something's wrong in it, can they fix their statement? Like if they've already submitted an affidavit and they put something in there and found out it wasn't true?
Yes, you can file a notice of correction, or you don't have to title it a notice of correction, but basically you can send whoever you sent the affidavit to that had the incorrect information in it. You would need to notify them immediately of what the incorrect information was, what the correct information was, and basically you would want to let them know that the mistake was made in good faith. It wasn't done intentionally meant to be a lie or be incorrect or anything like that. So you can do that. You definitely want to let the adverse party know, like I said, what was the incorrect information and what the correct information should be.
So just for clarity, if you made a mistake in an affidavit and you did not send a notice of correction stating what the mistake was and what the correct information is, then could the whole affidavit be thrown out?
Absolutely, because if the incorrect statement was left without being corrected, then you're opening yourself to impeachment on that particular fact, which can lead to impeachment on the whole entire affidavit. We recently did an affidavit where the date was wrong. We said it was June 9th or something, or June 19th. We sent the affidavit to where it needed to go, and then we realized afterwards that the date on the affidavit was incorrect, so we informed them that in points 1 and 2 of the affidavit, where we stated that the date was June 19th, that was factually incorrect, and that it should have been June 21st. But you also want to let people know if you end up doing a notice of correction, you want to also inform people that you're only correcting the incorrect information in whichever points had the incorrect information, and that everything else stands as true.
In the process of writing the affidavit, you go over your case in chronological order and you lay out the facts, what is relevant to the case. What is there a best method for separating facts from conclusions? Like how can someone who doesn't know the difference between the two?
I would just say, in general, the best way to separate facts from conclusions is if you have firsthand knowledge of a thing that happened. A car was speeding down the road and crashed into a tree. A conclusion would be that the driver was drunk. You have no firsthand knowledge. You saw the car go down the road, you saw it smash into the tree, but you don't have any actual evidence or firsthand knowledge of the fact that the driver was drunk. You can presume that, but that's a conclusion. So basically anything that's outside of exactly what you witnessed is generally, I would call that a conclusion and not a fact. You definitely don't want to put conclusions in your affidavits. You only want to state facts. That's it.
Do affidavits have to be notarized?
No, there's different ways you can make them just as valid. There's a federal statute that you can actually write onto the document that by making a statement that you're doing it under penalty of perjury in accordance with the laws of the state that you're doing it, or the United States. That's one way to do it. You can have 2 or 3 witnesses witness your signature on the document, but no, it doesn't have to be notarized. I mean, in my opinion, it should be, and especially if you're going to use it as testimony, you don't want to just have your signature notarized, which is an acknowledgement. You want to have a jurat on there, which is where the notary actually makes you raise your right hand and swear under oath that everything in the affidavit is true. So if you want to use it as testimony, it's best to have it notarized, yeah.
So why don't public officials have to notarize their statements? Like if someone makes a statement,
some do, some don't. It really depends on the statutory structure of the agency that they're working for. Some agents are automatically presumed to be telling the truth or under oath or under penalty of perjury, and some aren't. So I mean, it really depends on the agency and the agent themselves and what position they're in. So no, public officials don't always have to have their claims notarized.
So, as the foundation for the private administrative process, affidavits are super important and should be carefully and deliberately crafted and handled. So, we've established that. So, what kind of situations can they be used?
Any situation where you want to make a claim or offer testimony. I mean, really, any situation you can use an affidavit for pretty much anything you want. Again, it boils down to it's simply nothing more exciting than just it's a sworn statement of fact. So, I mean, you can use an affidavit for anything that you want to establish, any kind of situation where you want to establish a set of facts, you can use an affidavit for. So, pretty much anything commercial, banking, legal, wills, trusts, probate. I mean, really anything that you want to just establish a set of facts, you can use an affidavit for.
So, what are the benefits of doing the private administrative process if you have?
Well, the benefits of it are, again, you're keeping it out of the public view. You're keeping whatever issue you have with whoever you have it with, and again, the banks, the dog catcher, public officials, but you're keeping it out of the public in general. So a private administrative process is exactly that. It's private. It's between yourself and whoever that you have the issue with. And you can use this private administrative process to establish the facts, and even including, monetary damages. You can use it to establish that. You can use it to establish what somebody owes you. You can use it to establish any set of facts at all, but you do it to keep it out of court. Mostly it's to keep it out of the public. The adverse party happens to be an honorable person. You send them your claim and you say, oh, well, your tree fell in my yard and I think you owe me $500 to repair my fence. Well, if your neighbor that you're doing this private administrative process with is honorable in any way, shape, or form, he might just go, oh, I didn't know my tree fell in your yard. But now that you've established that as a fact, I'd be more than happy to give you, here's $550, here's $600, or even just here's the $500 you asked for. It's all done, it's a way to establish that you've at least approached a possible issue and remained in honor by informing the adverse party of what the issue is.
Your process is a little bit different. So what are the benefits of having the Secretary of State sign off on the process?
Well, when you get an administrative judgment and then you have it apostilled, it's one of the benefits is if for some reason the accounts aren't settled or the situation isn't resolved and it does end up in court and a judge rules against you, basically what you're doing is you basically bypassed your issues by using the Secretary of State to get an apostille on an administrative judgment. If the judge does rule against you, then it's a fight between the judge and the Secretary of State because you've already established your facts. So that's one benefit that you can utilize it for. Also, anything that's apostilled can be used in a foreign country. So say you do your private administrative process, you get an administrative judgment, and then you get it apostilled. Say I got an administrative judgment saying John Smith owes me $4 million, and I get that judgment apostilled, and say John Smith only has, he has one house in the United States. It's worth $100,000, but he's got $10 million worth of property overseas. I can take that apostilled administrative judgment over to the country that he has $10 million worth of property, and I can record it there and it'll be valid. So you can enforce it there as well.
Can anyone do a private administrative process?
Absolutely.
You don't have to be a lawyer?
Nope. It's not even a legal issue. It's not even a legal process. It's a commercial process. That's all it is. It's prejudicial. Yes, anybody can do a private administrative process anytime they want to solve or to either, again, establish facts, settle an issue, or, create resolution and remedy.
What kind of situations are not suitable for the private administrative process?
Well, it would be like a situation, let's go back to the tree in the yard, your neighbor's tree falls in your yard. Now, if you see him out, in the yard and you say, hey, your tree fell in my yard, and he says, okay, well, you want $500, I'll give you $250 now and $250 next week. I mean, if he keeps his word, then, anytime you can settle a dispute or create resolution or remedy, verbally, you really don't need a private administrative process. You wouldn't want to use it once the guy gave you the $500, the situation's resolved. You don't want to say, oh, well, let's just let's just put it on paper. No, the situation's resolved. Anytime you can create a remedy without using a private administrative process, you shouldn't. I mean, you definitely shouldn't use a private administrative process if you can settle things in personally.
Right. What about for things like, the school lunches are not healthy for the kids? Is a private administration process something that would be used against the school board or the cafeteria?
Absolutely.
Really?
Absolutely.
What about things like trying to come up with an example? My kid got bad grades and got held back a grade, and I want him to be advanced. Is that something you can use a private administration process?
Sure, absolutely. I mean, you can go to the school board and you can have a discussion with them about why your child should be advanced into the next grade. If they disagree with you and they refuse to move your child forward, then now you have what the courts call an issue of material fact and dispute, right? So now there's an actual issue there. But if you go to the school board and you say, hey, this is why I think my child should be advanced regardless of your policy, and they say, okay, you know what, we agree with you, and they advance your child, then again, the situation is resolved. You don't need to do a PAP. But if you don't need to use a private administrative process generally until there's an issue that needs to be resolved. That's the whole point of it, is to resolve issues on paper before going to court, outside of court, without court. We don't need to go to court every time somebody owes us money. We can just say, hey, we send them if your car gets towed and the tow company sends you a bill for $100 for the towing, they're not filing a suit against you. They're filing a claim. That when they send you that bill, that is a form of private administrative process. They're saying, hey, you owe us $100, please pay us. And then you can do the right thing and say, oh, okay, here's a check for $100. Or you can go down there and pay the $100. That's the right thing to do. Now, if you don't pay that $100, what's the other options? You can send them a letter back going, hey, screw you, I'm not going to pay you. I don't think I owe you anything, which is rude and unnecessary. And they'll send you another bill and you don't pay that. And then they send you another bill and you don't pay that. They've done 3 private administrative processes on you. They've defaulted you, and now they will take you to court. But, say you couldn't pay it the first time they sent you a bill and you said, hey, I can't pay this. And they send you another bill and then you can pay it and you pay it. I mean, that's what a private administrative process is. It's private between the tow truck company and you. It's their way of saying, hey, we have an issue. We would like you to resolve the issue. And as long as you resolve it, then they're not going to take you to court before they send you a bill. They're not just going to sue you for $100. They're going to send you a bill first. That bill is a private administrative process.
So how often do private administrative processes get dismissed as frivolous, and for what reasons?
Are you talking about in court?
Do they get dismissed privately as frivolous? I mean, like if somebody says, hey, your affidavit is insufficient and we don't have to do anything with it. So file 13 it. Does that happen?
Well, it does happen, but technically what they should do, what the adverse party should do, is send you a notice stating, which is their private administrative process. They should send you a notice back saying, we believe your affidavit is insufficient, frivolous, and they should tell you it is and why they believe it is, right? Because they might be right. Maybe your affidavit was frivolous. Maybe maybe some other thing happened that made it completely frivolous. But they should, but yeah, sometimes they don't. Sometimes they don't send you any response. They just throw it in the garbage and they dismiss it. Well, hey, look, man, I tried to fix the problem with this process. You didn't even want to respond to me, so I'm going to send you another notice telling you you're at fault now. And if you don't respond to that, I'm going to send you my third notice saying that you're in default. And then I'm going to get my administrative judgment. I'm going to take all that. I'm going to get it apostilled and take it into court and tell you, I'm basically going to use that to get the judge to tell you what I already told you 3 times. So
mostly court cases, like an affidavit that is, or I guess the private administrative process that was submitted into a court case, can be dismissed as frivolous. How do you avoid having your affidavit dismissed as frivolous?
Well, again, if it ends up in open court like that, and a judge or a prosecutor or another lawyer, if it's a civil case, whoever's prosecuting the case for their client in a civil matter, if they say it's frivolous in open court, then the easiest way to get past that is now they've made a claim. You got them to make the claim that your thing was frivolous. So now, right, the burden of proof is on the accuser. If they're saying it's frivolous, now they have to prove that it's frivolous.
How do you avoid having your private administrative process dismissed as frivolous?
The best things to do to avoid that from happening is to make sure that every point in your affidavit is made true, correct, and complete. Always tell the truth. Always be 100% correct. Don't make your points of fact frivolous in general. Like when a well-written affidavit is the best way to do it, is to to write it properly and make sure that each point of fact, each point in your affidavit is specific to one fact, and that it is absolutely true and unrebuttable and provable. If you can prove the fact that you've made in your affidavit, then they can't disprove it, and if they can't disprove it, then it's not frivolous.